7. Law and equality. Death is the end of the conflict, and a society in search of a false peace is in search of death. An anthropologist has written, quote, "Conflict is useful. In fact, society is impossible without conflict. But society is worse than impossible without control of conflict." The analogy to sex is relevant again. Society is impossible without regulated sexuality. The degree of regulation differs among societies, but total repression leads to extinction. Total lack of repression also leads to extinction. Total repression of conflict leads to anarchy just as surely as does total conflict. We Westerners are afraid of conflict today because we no longer understand it. We see conflict in terms of divorce, rioting, war, and we reject them out of hand. And when they happen, we have no substitute institutions to do the job that should have been done by the institution that failed. In the process, and to our cost, we do not allow ourselves to see that marriage, civil rights, and national states are all institutions built on conflict and its sensible, purposeful control. There are basically two forms of conflict resolution: administered rules and fighting, law and war. Too much of either destroys what it is meant to protect or aggrandize." End quote. Bohannon's position is humanistic and relativistic. As a result, the conflict in a society of his character will tend to anarchy. With every man a law unto himself, with no absolute other than man's will, total conflict and total anarchy will be the only alternative to a totalitarian regime. The problem of conflict cannot be resolved in any just and orderly manner in a relativistic society. Since every perspective, religion, and philosophy is made legitimate, and all people are made citizens, in effect, every possible kind of law and every possible culture is admitted to legality. Either a repressive and totalitarian state then suppresses all, or all prevail and anarchy reigns. Individualism and collectivism are both products of liberalism. Ellul has observed, quote, "It is believed that an individualist society in which the individual is thought to have a higher value than the group tends to destroy groups that limit the individual's range of action, whereas a mass society negates the individual and reduces him to a cipher. But this contradiction is purely theoretical and a delusion. In actual fact, an individualist society must be a mass society, because the first move toward liberation of the individual is to break up the small groups that are an organic fact of the entire society. In this process, the individual frees himself completely from family, village, parish, or brotherhood bonds, only to find himself directly vis-à-vis the entire society. When individuals are not held together by local structures, the only form in which they can live together is an unstructured mass society. Similarly, a mass society can only be based on individuals, that is, on men in their isolation, whose identities are determined by their relationships with one another. Precisely because the individual claims to be equal to all other individuals, he becomes an abstraction and is in effect reduced to a cipher. As soon as local organic groupings are reformed, society tends to cease being individualistic and thereby to lose its mass character as well. What then occurs is the formation of organic groups of elite in what remains a mass society, but which rests on the framework of strongly structured and centralized political parties, unions, and so on. These organizations reach only an active minority, and the members of this minority cease to be individualistic by being integrated into such organic associations. From this perspective, individualist society and mass society are two corollary aspects of the same reality. This corresponds to what we have said about the mass media. To perform a propagandistic function, they must capture the individual and the mass at the same time." End quote. Liberalism dissolves the religious and familial ties of a society and leaves only the rootless individual and the humanistic state. Society then veers between collectivism and individualism. A social order which denies that God is the source of law must of necessity seek its principle of law from within history or from man. The conflict of law, then, is no longer between God's law and man's sin, but it is now the law of some men's ordering, which now makes sinners of all other men who differ. The law also shows, then, an ambivalence between an aristocracy suppressing the people and a democracy seeking to suppress the aristocracy. Gray's comment on the purpose of civil government shows the problem clearly. Quote, "That order is usually regarded as the prime object of governments will not be denied. The means of enforcing order differ in different communities, and it is reasonably plain, other things being equal, that the best government for enforcing order is the government which is able, without check of any sort, to impose its restraints upon the individual, that is, a despotic government. Why then, if order is the first object, and a despotic government is the best means of enforcing order, are not all governments despotic? Because, quote, all men are born equal, end quote, because every man born on the earth has the same right to use the earth as every other man. Thus it is perceived that this order, which is the object of government, is not the ultimate end of government, but is merely a means whereby the equality to which men are born may be enjoyed. If this be true, the ultimate principle upon which governments depend is equality, and the law of unity which regulates the operation and the organization of governments is the law of equality." End quote. Gray admitted that, quote, equality is a mathematical term, end quote, and one would expect that he would have seen the impossibility of applying a mathematical abstraction to man. On the contrary, he favored its application to taxation, the subject of his study. He admitted that the principle of equality was an American development of the past 50 years, that is, since the Civil War, since Gray published in 1906. Gray's concept of equality was close to the Marxist principle of equality, since he felt that, quote, "It is plain that equality does not necessarily consist in mere equality of contribution. For every man, rich or poor, to pay the same would be the greatest inequality. Whether it consists in proportionate contribution according to property is a question which has been much discussed. In the common forms of property taxation, this is the method in which the courts have usually found that sufficient equality inheres. A great economist has said that equality in taxation consists of equality of sacrifice. The courts have usually measured equality in taxation by reference to the amount of benefits received, rather than by considering the sacrifice of the taxpayer. The economists of the present day seem to prefer the idea of equality of sacrifice. A glance at the two chief economic theories of taxation shows the distinction between the equality based on proportionate contribution and equality of sacrifice." End quote. Gray denied the quote-unquote benefits theory of taxation. If those who benefited the most paid the most taxes, then the poor and weak would pay the most, and the rich and strong the least. From Gray, it is clear why the income tax amendment came into being. It was quote-unquote necessary in terms of existing presuppositions. But the consequence of Gray's theory is that the people are leveled, stripped of power, to create a state which is not quote-unquote equal to the people, but far superior and able to crush them. Quote, "The power of the state, acting through its governmental agencies to tax its citizens, is absolute and unlimited as to persons and property. Every person within the jurisdiction of the state, whether citizen or not, is subject to this power. Every form of property, tangible or intangible, stationary or transitory, every privilege, right, or income which exists within the jurisdiction may be reached and taken for the support of the state. This doctrine is involved in the general theory of the state. The state exists for the purposes of law, order, and justice. The preservation and security of life, liberty, and property depend upon the existence of the state. Inasmuch as all private ownership of property is postulated on the existence of the state may properly exhaust all the resources of private property in the support and preservation of that existence. Inasmuch as all privileges and liberties derive their value from the protection of the state may take any share of the value of those privileges and franchises for its support, even to the extent of the whole value." End quote. The state thus becomes the total institution, comprehending the life and property of man. The state can confiscate all things to ensure its own existence, because the state has implicitly become the basic value. In the United States, the property tax developed in New England in the 17th century, but it was limited at first in its extent. The South resisted it for a time. The transition to a humanistic concept of the state was both gradual and steady. In the 20th century, taxation began to serve as an instrument of social and economic change. Thus, taxation no longer serves simply to support civil government, but also to reorganize society in terms of leveling and equalitarian concepts. In this newer concept of taxation, the new established religion of the United States, humanism, came to focus. God being denied as the source of law, law has moved steadily to enforce a totalitarian and equalitarian principle. In biblical law, neither equalitarianism nor an oligarchy have any standing. God as the source of law established the covenant as the principle of citizenship. Only those within the covenant are citizens. The covenant is restrictive in terms of God's law. It is also restrictive in terms of a bar against membership, which appears specifically, naming certain kinds and groups of persons. This aspect of the law is usually overlooked because it is embarrassing to modern man. It needs, therefore, especial attention. In Deuteronomy 23, 1-8, eunuchs are barred from citizenship. Bastards are banned through the 10th generation. Ammonites and Moabites are either banned through the 10th generation, or they are totally excluded, depending on the reading of the text. Edomites and Egyptians were eligible for citizenship in their 3rd generation. The implication is that they are eligible after 3 generations of faith, after demonstrating for 3 generations that they believed in the covenant God and abided by His law. The throne being the ark in the tabernacle, and the tabernacle being also the central place of atonement, membership in the nation civil and in the nation ecclesiastical were one and the same. Citizenship rested on faith. Apostasy was treason. The believing alien had some kind of access to the sanctuary, 2 Chronicles 6, 32-33, at least for prayer. But this act did not give him citizenship. The alien, Egyptian, Babylonian, Ethiopian, Philistine, Phoenician, and any others, could be citizens of the true or heavenly Zion, the city of God, Psalm 87. But the local Zion, Israel, was not to admit the banned groups except on God's terms. Entrance was possible by marriage to a male Israelite, Ruth 4:6, but not directly. A woman assumed the status of her husband. Now, in all this, one thing is certainly absolutely clear. There is no equalitarianism here. There is an obvious discrimination and distinction made which no straining can eliminate. At the same time, the one law requirement of Exodus 12:49 made clear the absolute requirement of justice for all without respect of persons. Thus it would appear from the evidence of the law that first, a restrictive membership or citizenship was a part of the practice of Israel by law. There is evidence of a like standard in the New Testament church. Instead of being forced into rigid uniformity, Gentiles and Jews were free to establish their separate congregations and maintain their distinctive character. Moreover, Acts 15, the Council of Jerusalem, makes it clear that the differences in cultural heritage and stages of moral and spiritual growth made possible major conflicts in case of uniform membership. As a result, separate congregations were authorized. On the other hand, Jews were not barred from Gentile congregations, so that, while restrictive groups were valid, integrated groups were not invalid. Second, the predominant fact in Israel was one law for all, irrespective of faith or national origin, that is, the absolute requirement of justice for all, without respect of persons. Similarly, in the Church of the New Testament there was one Lord, one faith, one baptism, Ephesians 4:5, in the true church, and the true kingdom of God. The limited local membership was valid, but the universal sway of the kingdom and the common citizenship of all believers are the basic and governing fact. The reality of local distinctions cannot, however, be obliterated by the ultimate and essential unity, which is not to be confused with uniformity. Equalitarianism is a modern politico-religious concept. It did not exist in the biblical world, and it cannot, with any honesty, be forced onto biblical law. Equalitarianism is a product of humanism, of the worship of a new idol, man, and a new image carved out of man's imagination. As a standard in religion, politics, and economics, it is a product of the modern era. To read it into the biblical faith is to do violence to Scripture and to be guilty of dishonesty. The excluded persons of Deuteronomy 23, 1-8 are of interest. Bastards were excluded to the 10th generation. Eunuchs were excluded, whether eunuchs by an accident or by act of man. Because eunuchs are without posterity, they have no interest or stake in the future, and hence no citizenship. Persons of a lower moral culture, such as Ammonites and Moabites, were also excluded. The purpose of exclusion was the preservation of the covenant in the hands of responsible leadership. The limitations on Edomite and Egyptian membership served the same function. Eunuchs were commonly used in antiquity for civil office, and in Byzantium were the civil service. Precisely because they had no stake in the future, eunuchs were entrusted with positions calling for an exclusively present loyalty. The eunuch, as a kind of existentialist mentality, was severed from past and future and bound to the present. Hence, he was preferred over family men. In colonial New England, the covenantal concept of church and state was applied. Everyone went to church, but only a limited number had voting rights in the church, and therefore in the state, because there was a coincidence of church membership and citizenship. The others were no less believers, but the belief was that only the responsible must be given responsibility. One faith, one law, and one standard of justice did not mean democracy. The heresy of democracy has since then worked havoc in church and state, and it has worked towards reducing society to anarchy.